This is Immigration Attorney Gail Seeram, and we did so well last week with the live session that we decided that we're going to continue going live every Wednesday at 1 p.m. so we can bring you live immigration info. Sorry for the delay this afternoon. We have some trouble on Facebook, so I hope this is going live on our Facebook group page. This afternoon, we are still going to take your questions. So go ahead, and we are on 3 platforms this afternoon. We are on our YouTube page, and we are on TikTok, and we are on Facebook. So you can always find us across all social media by hashtag GailLaw. That's hashtag, which is the number sign, GailLaw across all devices. We have been practicing immigration law for 22 years, and we're more than happy to assist you with your immigration question. Now, this is a 30-minute session that we're doing today. If you like what you hear and what you see, go ahead and tap your screen, like and share so we can reach a greater audience this afternoon. We have been practicing immigration law, as I mentioned, for 22 years. We do offer a free consultation with exceptions for certain cases. You can call our office at 407-292-7730 or WhatsApp us 407-353-1363 to find out if you can get a free consultation to discuss your immigration question. Again, we want you to like, heart, tap your screen, and share, and go ahead and subscribe to all of our social media platforms. This afternoon, as I see the questions pop up, we will go ahead and answer your questions, but I do have a specific topic that I wanted to discuss this afternoon, and that topic is entry to the United States, which is, the question that we get the most. How can I enter the United States? Or I try to enter the United States and I had problems. I was held up. I went to secondary inspection, or I was denied entry. So entry to the United States is a big topic. So go ahead, and I see some questions coming through on TikTok. Post your questions. I'm going to talk a little bit about entry to the United States, and then I will also go back and answer your questions also, okay? So let's talk about a word that I just mentioned, secondary inspection. What is secondary inspection? Anyone who's coming to the United States, and if you're coming in with a tourist visa or even a green card, you are applying for admission into the United States. So even if you have a tourist visa or you have a green card in hand, that just gets you on the plane. Once you're on the plane and you come off the plane, you see an immigration officer. You form a line in U.S. Customs and Border Protection. You go online, you see an officer, you present your passport. That officer will ask you for the reason for your entry. If you're coming in with a tourist visa or a green card, they may say, why were you outside the U.S. so long? But once you're entering the United States and you're in front of that officer, if that officer tells you, please come off the line and go in that room, or an officer comes to get you and takes you off the line, the room that you're going into is what we call secondary inspection, meaning that's the room where an officer may have further follow-up questions, and they're going to ask you some questions before they allow admission, okay? So when we're talking about entry into the United States, there's pretty much 4 categories of entry into the United States. The easiest entry is category number one, which is a U.S. citizen. If you are a U.S. citizen, you are allowed entry into the United States, and you are not applying for entry into the United States. A U.S. citizen is always allowed entry into the United States. So category 1, entry into the United States, U.S. citizen, always allowed in, okay? Let's talk about the second type of entry, someone who's entering with a green card, permanent resident status. It could be a permanent resident that has a 2-year status, or a permanent resident that has a 10-year status. So there's a 2-year green card and a 10-year green card. The 2 years conditional being married to a U.S. citizen. The 10 years a full 10-year card. Once you're entering with a green card, you are applying for admission, okay? The officer can question why you were out for so long. The officer can look at your criminal history. If you have certain crimes, if you've committed in or outside the United States, they can use that if it's a crime of what we call inadmissibility, a crime that they could use to hold against you to not admit you into the United States, and they could choose to not, let you into the United States. So a green card holder is our second category of person who's seeking entry into the United States. Okay. And I'm going to pause there. So we talked about two types of entries. One, a U.S. citizen seeking entry, and a U.S. citizen is always allowed entry into the United States. And category number two, a green card holder, a 2-year or 10-year green card holder who is applying for admission into the United States. I'm going to pause there before we go into the other two categories of people who seek entry into the United States. If you liked what you heard, again, tap your screen, like, and share so we can reach a broader audience, friends. So let's go and take some questions that we see coming in. If someone is applying for citizenship, is currently going through a divorce. Well, if you're applying for citizenship and you're applying for citizenship based on 5 years, it doesn't matter that you're going through a divorce. So if that person can clarify if they if they are applying based on being a permanent resident for 3 years, meaning 3 years from the card being issued, or if they are applying for citizenship based on 5 years. If you're applying for citizenship based on 5 years, then it doesn't matter that you're going through a divorce. You can, if you're currently, the divorce is pending, then on the application when you would list yourself as maybe separated from your spouse. And then when you have the interview, the officer may ask to see the final divorce decree. So you don't have to wait until you have the final divorce before you apply for citizenship. You could apply for citizenship. However, if you are applying for citizenship based on 3 years, because 3 years is you're filing based on marriage to a U.S. citizen and you're now divorcing that U.S. citizen husband, then you cannot file for citizenship because you're proving that you're still married to that U.S. citizen as part of being able to apply early based on 3 years. So if you can clarify that for me, but if you're filing based on 3 years of residency, then you cannot file for citizenship if you're getting divorced from the U.S. citizen husband. If you're filing based on 5 years of being a permanent resident, then it doesn't matter that you're getting divorced, okay? Finalize, they need to add the spouse information, but don't have that, okay? It's 5 years. Okay, so if it's 5 years, it doesn't matter that you're getting divorced, but you still have to list that spouse as a spouse because that person's still legally your spouse because you're not divorced. So on the citizenship application, you have to list that person as a spouse and you could put separated, okay? But you can still go ahead. Just know when you're applying for citizenship, and I tell people this all the time, you are literally reopening your file. When you file for citizenship, they're just not keeping to the four corners of your citizenship application. They are looking back from day one when you enter this country. How did you enter? Did you enter with a tourist visa? Did you lie on that tourist visa to gain entry to the U.S.? How did you get your green card? Was it through marriage? Do we think your marriage was fraud? Was your marriage good faith? So they're looking back from day one of your immigration history when you're applying for citizenship. So do keep that in mind. If you have a citizenship interview coming up and you would feel better if you had an attorney prepare you for that citizenship interview, we do offer that service where we do a mock interview and we prepare you for potential questions that officer is going to ask you. So there are no surprises for you at your citizenship interview. Okay. I applied for spousal visa for my husband. Wow, I saw something come up on YouTube here, but then it just disappeared on me. Okay. If that person who asked that question on YouTube can go back and ask me that question because it just disappeared. So if you can, the YouTube person just ask me that question again so I can answer your question. The other question that we got is, my dad filed I-130 and not married, have a visitor visa, I've traveled 2 or 3 times. What should I do? How long my priority date? Okay, so if your dad filed a petition for you, and I believe it said that you were unmarried. So if it's I need to know for my YouTube friend if your dad was a U.S. citizen or a permanent resident, because that makes a difference in the wait time. But let's assume for that question, if dad is a U.S. citizen filing for an unmarried child, over 21, oh, he's a permanent resident. Okay. If dad was a U.S. citizen filing for unmarried child over 21, they're working on December 2014. Okay, so you have about a 8-year wait. If dad is a permanent resident, which is what you just specified, dad is a permanent resident filing for an unmarried child, they're working on September 2015. So that is about a 7-year wait. So you have to look at your receipt notice and see the date that that petition was received, and that will tell you how much longer you have. I think you did tell me the date. So say dad filed in 2010, they're up to 2015 right now. So you have about a 5-year wait. So I hope that answers the question for our friend on YouTube. We're going to go back to your questions again. This is Immigration Attorney Gail Seeram, practicing immigration law for 22 years. We offer a free consultation with some exceptions. You can call our office, text our office, and WhatsApp our office. Those numbers are all in our profile in the social media platform that you are on right now. I applied for a spousal visa for my husband. We married in Africa. If you file a petition based on marriage, that takes about 9 to 12 months, and it has 3 steps. First, it's the marriage-based petition, and then the file goes to the visa center in about 6 to 9 months, and then about 9 to 12 months, the file goes to the embassy in Africa for your interview. So to our TikTok friend, if you have a follow-up, but that processing time is normally 9 to 12 months with 3 steps. So I would encourage you guys to share. I'm not seeing enough of you sharing and tapping. You welcome there, our YouTube friend, and please go ahead and share our videos. And when we're done, go ahead and share this video, because you don't know who may have that same question. How can I get my granddaughter to come up for Christmas? To our friend Julie, if that's for a tourist visa, if you want your granddaughter to come up on a temporary basis to visit you here, if she's a minor, she cannot apply on her own. She will have to apply with a parent. So a parent would have to apply for that tourist visa. Tourist visa applications are now submitted through the U.S. Embassy website for the country where that person is a citizen of, or living. So if that person, let's say is in Nigeria, your granddaughter, then she would apply through the U.S. Embassy website for Nigeria online. And you go to visas, non-immigrant visa, tourist visa, and you would submit that online application there, okay? Don't get caught out there by a lot of these cyber offices or tourist offices. They do not have to submit that tourist visa application for you. You could submit it on your own online by visiting that U.S. Embassy website for the country where you live, and you could submit the application, and they will set an appointment time for you to go into the embassy. Okay. Going back to our TikTok friends, my spouse I-130 was approved 2 years ago and transferred to the visa center. It's been 2 months. So if your file just went to the visa center, then the visa center will ask you to upload documents. We do assist with that. You could, for that particular case, since you have a pending filing, it is $100 for that consultation fee. We would be more than happy to look at your case at the visa center and let you know if something is missing, and get that case, what we call documentally qualified. When a case is at the visa center, all the documents need to be submitted, and the case has to be documentally qualified before it moves on to the next step, which is the embassy interview. Okay. And another person, again, filed for husband 2019, pay the visa fees, finished everything. He's waiting a visa. You have to make sure he's finished with everything. If the case is at the visa center, just because you submitted all the documents doesn't mean you're finished. You want to log in. And again, our office does offer assistance. You want to log in. You want to look at the visa center, make sure all the documents were accepted, submitted. You want to look at messages. If you did not get an email from the visa center, and this is for processing outside the United States. We're talking about when you're filing for a family member outside the United States. If your case is at the visa center, if you did not get an email from the visa center saying your case is documentary qualified, then your case is not done at the visa center. And again, you can set a free consultation with our office. Actually, in this situation, it's $100 for the consultation since it's a pending case, and we would be able to look at it and let you know if there's a holdup, what is the issue at the visa center. My mom has her green card and is outside the U.S. for 15 months, I believe I just saw. If mom has a green card and she's been out for 15 months, she called the embassy and was told, I can't see what else she was told. She called the embassy. If she's been out for a year, if you have a green card and you're out for more than a year in the day, in this situation, 15 months, then you technically abandoned your residency and you will have to contact the embassy. Only they can take evidence and determine if a reentry permit is warranted so you can be allowed back in the United States. So that's only can be done through the embassy. I have a 2-year devoting now what to do by 10-year. If you have a 2-year green card, that's a conditional card. The only way to get the 10-year card is filing a petition to remove those conditions. We'd be more than happy to set a consultation, discuss with you what the steps and requirements are for that process to remove your conditions. To our TikTok friends, so go ahead and call our office, 407-292-7730, or WhatsApp, 407-353-1363. We could set that consultation to discuss the steps of removing the conditions so you could get that full 10-year green card. You're supposed to leave by the end of June, but your mom has lots of health issues. I'm assuming you're here on a tourist visa. You have to leave by June. If you have to leave by June, if you were given that 6 month, then I would advise you to leave because the process to file for an extension of stay is taking over a year. So you may not get that decision before you're supposed to leave. And you don't want to overstay. You don't want to be out of status because if you file for that extension and even if it comes back and they approve you, they only give you an additional 6 months and you may end up overstaying if you're supposed to leave by June. My spouse, I-130 was approved. Okay, we went through that. Waiting for appointment, 60-day notice, 10-day notice. I don't understand that question from Selena. Waiting for his appointment, but they kept send him a 60-day notice and now he's on a 10-day notice. I don't understand that question. If you could elaborate a little bit more. Can I override my ex refusing to take my son for his visa interview? Well, if your child is outside the U.S. and they have a visa interview, it can be any adult that takes that child in. It doesn't have to be your ex. Or maybe an option is you may want to fly back to your country if that's an option and take your son to the embassy interview. But you can also have a guardian, any adult, take the child in and maybe give an authorized letter to the adult outside the country, authorizing that adult to take your child into the embassy interview. So it does not have to be your ex-husband. How long does it take to obtain the green card for a parent? If you're a U.S. citizen filing for a parent, whether that parent is in the U.S. or whether that parent is outside the U.S., it's about 9 to 12 months. A parent is considered an immediate relative of a U.S. citizen. So if you like that answer, go ahead and, tap your screen, like, share, so we can get all this information out to a broader audience. Again, this is Immigration Attorney Gail Law. Find all of our information on social media by a simple hashtag Gail Law, hashtag GailLaw. We'll be more than happy to help you. In and out of the hospital, making it very challenging to travel back to the U.S. Again, if you're out of the U.S. and you've been denied entry, you have to speak with the U.S. Embassy in your country. That's the only way that you're going to be allowed back in. Well, let these questions accumulate. I want to go back to our main topic. I will continue to answer the questions, but I want to go back to our main topic this afternoon, which is entry into the United States. And it's what we first started talking about. There are 4 categories of people that seek entry into the United States. First category and the easiest category are U.S. citizens. U.S. citizens are not applying for admission ever to the United States. A U.S. citizen is always allowed admission into the United States. So that's category 1. The second category of individuals are green card or permanent residents. They are the second category of individuals that try to enter the U.S. A green card holder could be a 2-year or 10-year green card holder, but a green card holder in general is always applying for admission. You present your green card, your passport, and you are applying for admission. You can be denied admission if there's some kind of ground of inadmissibility, we call it, a ground where an officer could deny admitting you back into the U.S. That can be because you stayed out for a long period of time. That could be because you committed a crime or you have a criminal history in your record. So if you're a green card holder, we always say speak to an attorney before you leave the United States if you think you have a possible ground of inadmissibility. where an officer can deny admitting you back into the United States. But a green card holder is always applying for admission. So that's category 2. Category 3 are our non-immigrants. This is the third category of individuals who are seeking entry into the United States. A non-immigrant is someone who's coming with a tourist visa, a B1, B2, someone who's entering as a student, an F1 visa, someone who's entering to work on a temporary basis. That could be an H2B worker, that could be an H1B worker, that could be a J1 visa holder coming to work or intern in the United States. It could be a Q visa holder. So there are a multitude of non-immigrant visas. Again, non-immigrant is non-immigrant, and you are also applying for admission into the United States. So that's category 3, non-immigrant visas, third category of person seeking entry into the United States. So we have U.S. citizens, category 1, we have green card holders, category 2, and we have non-immigrant visas. That's category 3. What's category 4? Category 4 are someone who's been deported, okay? So if you've been deported or removed from the United States, you can also seek admission into the United States. There is a process to seek reentry where if you have been deported and you want to seek reentry, you have to have approved family-based petition and approved waivers. Anyone who's been removed has to file a waiver asking for permission to return to the United States. And also, if you still have that criminal record, you have to ask for a waiver for that ground of inadmissibility, meaning that criminal ground that they could deny you returning to the United States. So those are our 4 categories of people who seek entry to the United States. I'll repeat them. Category 1, a U.S. citizen. Category 2, a green card holder, 2 or 10-year green card holder. Category 3, non-immigrant visas, temporary visas to work or visit. And category 4, anyone who's been deported who is now seeking readmission. Okay, and there are different rules that apply to those 4 categories, and we'll be more than happy to assist you if you fall in any of those 4 categories and you are seeking assistance to gain entry into the United States. We are going to go back to our questions. And if we change address at NVC, do we need to change address with USCIS? If your case is already at the Visa Center, you just have to change your address at the Visa Center. However, the person who submits the affidavit of support always has to keep immigration updated with their change of address, and there's a form for that. But if you change your address at the Visa Center, you don't need to go backwards and change your address with USCIS, okay? Because through the Visa Center, when your file goes to the embassy, you do notify them of your new address, okay? What is the category F3? Not moving forward. F3 is married child of a U.S. citizen, and that category is taken about 10 to 12 years. So it's not that it's not moving forward. There's just a lot of petitions filed in that category. And unfortunately, you just have to wait in line for F3 for my friend there who's asking that question. Just so you would understand, F3, which is a married child of a U.S. citizen, there's only 23,400 visas issued every year. So it's moving slow because there are obviously more than 23,400 petitions that are filed in a given year. So it becomes backlogged. So it's a 10 to 12 year backlog on that category. How long does it take for a mother of a U.S. citizen to file for her child under 21? Mother of a U.S. citizen filing for child under 21 is about 9 to 12 years. 9 to 12 months. 9 to 12 months. I got caught up in years with the F3. So a child under 21 of a U.S. citizen, 9 to 12 months, whether you're processing in the United States or outside of the United States. I was sponsored by my mom in 2012, and I was legally married at that time. Now I divorced. Well, when your file is either at the Visa Center or the embassy, then you can update that information by providing a divorce. If when your mom filed for you, you were married, then depending on the situation, the spouse may be included in the visa application. So you will have to notify the Visa Center when your file's at the Visa Center that you are now divorced. And again, we do assist with Visa Center cases. Okay, can you add someone to your approved U visa? I would wait until you, it depends on who that someone is. So there's specific rules on that U visa. So we'll probably have to set a $100 consultation to discuss that. If we change address again, we're broadcasting live on TikTok and on YouTube, our YouTube channel, and also on our Facebook page. What is the process after year ban is done? 10-year ban is finished. If you have a 10-year ban from returning to the United States, what we would want to do though is I would really want to order your immigration file, take a look at it and make sure it is a 10-year ban. But assuming it is a 10-year ban, then if you have a qualifying family member that's going to file for you to return to the United States, if it's a spouse, it's 1 year. If it's a parent, it can take, if you're unmarried, 6 to 8 years. If you're married, 10 to 12 years. But once the visa is approved, once the case is approved and the visa is sent to the embassy will deny your case, because once you've been quote unquote banned for whatever reason, you have to file a waiver seeking permission to return to the United States. So if your 10-year ban is because you were deported, to our friend on Facebook, if it's because you were deported, then we have to look at that and see if you qualify for a waiver to seek reentry. Okay, not everybody can seek reentry into the United States. So it's definitely a case-by-case analysis. We'd be more than happy to look at that for you. It is a $100 consultation. So for that particular situation, and we'd be more than happy to help you. You could send me an email at gail@gaillaw.com. That's GAIL@GAILLAW.com. Most of this information you could get from our website also, GailLaw.com, GAILLAW.com. Why NVC keep asking? Okay. Wow, a lot of questions. Okay. Something about same information. The Visa Center keep asking for the same information over and over. The Visa Center, they're asking for the same information because you're not submitting the right information, or maybe the document isn't scanned correctly. A lot of times the Visa Center wants to see when you're uploading documents that it's scanned and you can see all four corners. Again, we do assist with Visa Center cases. So it's a $100 consultation and we'd be more than happy to help you. Canadian wanting to become a U.S. citizen through marriage. If you're Canadian, first your spouse will have to file for you and you become a permanent resident. After you're a permanent resident, then you file on your own to become a citizen. If it's spousal, you first become a permanent resident and then you file to become a citizen. But we can definitely help you if you already are a green card holder. Again, contact our office, 407-292-7730, or go to our website, GailLaw.com, and you can actually click and make your own appointment. So we can discuss that further with you. And travel for stepson funeral pending I-45. So if you have a pending application for a green card here in the United States, hopefully, this is to our friend with this, trying to go to stepson's funeral. Hopefully you've applied for a travel document, Form I-131, that you would have filed in conjunction with your I-45, because when you pay that fee for your I-45, it included the fee for the I-131. So if you filed the I-131, you should have gotten a receipt. You can call the 800 number and make an appointment to go down to your local immigration office and apply for an emergency travel document, which you have to take that I-131 to show that you did file that. So if you didn't file the I-131, you want to go ahead and file that with the I-45, get a receipt, and then go down to your local immigration office for that reentry permit. How long did approve the petition for husband? If it's a spouse of a U.S. citizen, it's about a 1-year process. If it's a spouse of a permanent resident, then you're looking at it can take up to a 2-year process, either in the United States. The Visa Center keeps asking for 1099. 1099 is because you don't have a W-2. If they're asking for a 1099, they may think you're working for yourself as an independent contractor, or 1099 as an independent contractor. So maybe somewhere along the way, for a friend on TikTok, maybe somewhere along the way they think that you're self-employed, or maybe your tax return shows 1099 income. But again, we can't help with that visa center case. The friend on YouTube that just asked that question, can you ask it again? Because when the question comes up, it kind of disappears off my screen. Ask me that question again on YouTube. What is the processing time for fiance? I am not a big fan of fiance visas because right now they're very backlogged. I'm hearing stories about 2 years, 3 years. In most cases, it's better to just marry that person and file a spousal petition. With fiance, it's discretionary. It's a non-immigrant visa, and you may get most of the fiance visas I see across my desk are denied. So I would recommend a spousal petition. We do not handle U visas. Again, a lot of visa center questions. With those visa center questions, you could book a consultation with our office for $100. Make sure you give me your case number and your invoice number, and we could discuss it during a consultation. Okay. So we are keeping these sessions at 30 minutes, and we are doing these sessions every Wednesday at 1 o'clock. So we are more than happy to answer your questions. And we'll also, we'll have specific topics that we want to discuss. It's 6 months now since I do my biometrics. Okay. Well, processing time here in the United States, if you're filing for adjustment of status, can take 9 to 12 months. So, if you kind of have to wait for your turn in line, unfortunately. So I see a lot more people joining. So calendar this date and time, Wednesday at 1 p.m. Eastern Standard Time, for your immigration info from #GailLaw, Immigration Attorney Gail Seeram. Go ahead and like your screen if you like what you heard in the past 30 minutes, and share. We will be back live stream next week, Wednesday. Again, if you didn't get your question answered and you still have a question, I see the questions still flowing through on TikTok. Again, we'll be more than happy to assist you. You can text our office, call our office 407-292-7730, or you can WhatsApp us. I know we have a lot of friends from outside of the U.S. You can WhatsApp us 407-353-1363, or go to our website, GailLaw.com, GailLaw.com. Go to our website, and you can make an appointment. In some cases, if you have a prior filing, like our friends at the Visa Center, it is $100 for the consultation. But if you don't have a prior filing, if you don't have a prior arrest, and if you don't have a prior immigration court case, then you're eligible for a free consultation. And we'd be more than happy to answer your immigration questions. So friends, until next week, Wednesday at 1, we will say have a great day. And we are thanking you for all of your likes, and thanking you for following us this afternoon.